Welcome to the Roadmap to Expungement, presented by Neighborhood Legal Services Clean Slate Initiatives team. My name is Samantha Cox and I will be your presenter for this recording. I am a staff attorney here, a part of the Clean Slate team. And as a team, we provide assistance to folks who are system impacted, who might want to pursue different record cleaning options, or who might be facing a barrier caused by having a criminal record. This is a recorded presentation, and for information and accuracy purposes, the date of recording is July 30th, 2024. With any significant changes in the law, we'll continue to update the presentation and make this information as accurate as possible. So a little bit of background about who we are here as an organization. Neighborhood Legal Services of Los Angeles County was founded in 1965 as a part of our nation's war on poverty, and we're now one of the largest and most prominent public interest law firms in California. We provide free assistance to more than 150,000 low-income residents of the county every single year. And we staff over 200 employees. That includes attorneys, social workers, social services team, and an amazing support staff to cover a bunch of different areas of law. I will not go into every individual area we provide assistance in, but if you are interested, please visit our website at the bottom of this slide, nlsla.org, to learn more. You can fill out a form if you're interested in receiving services on our website. And at the end of this PowerPoint, I include our hotline information for you to call and speak to an intake screener. As a quick disclaimer before we get into the meat of the presentation, this presentation is intended to provide general legal information and legal education only, and we do not intend to provide any legal advice or intend to establish any lawyer-client relationship by giving this presentation. As I mentioned, we are a law firm in Los Angeles County, so this presentation provides general information about laws and regulations specific to the state of California. Okay, so here is our agenda. We do cover a lot of different topics in this presentation. First, we cover expungement, what it is and what the eligibility requirements are. Then we'll talk about getting your records, and these are the records we use in our practice to assess a person's expungement eligibility and the scope of their cases, so the rap sheet and court dockets. We'll then talk about preparing support documents, and these are the documents we include in our petitions to request an expungement with the court, and we talk about how to prepare those, what to start thinking about at this stage. We'll briefly cover different forms of supervision and what relief options are available there. And then finally, we round out this presentation with a Know Your Rights session. First, we'll cover employment under the California Fair Chance Act, and then we'll cover housing under the Fair Employment and Housing Act. And with that agenda overview, I do quickly just want to highlight the goal of this presentation. We've really geared this information and this presentation to serve our community members who might have a criminal record or folks who might work in the space of criminal record cleaning, who just want to learn more information about the process in general, what the court process is like, how to start preparing, and what important rights to know along the way. This is information we give to each and every one of our clients, but we do want to make this information publicly available and in an accessible way that folks can access at any time that works with their schedule, so that even if you might not be eligible for expungement or ready for expungement at this point, you do have the steps laid out from this presentation so that you are prepared when that time does come. And we wanted to make this information publicly available so that it's accessible by our communities. If you have any suggestions about how to make this information more accessible, we really appreciate that feedback. So let's get started. Our first topic, as I mentioned, is expungement overview and eligibility. So what exactly is an expungement? An expungement is not necessarily a perfect remedy. It does have some limitations. And it's really important to understand what exactly an expungement cannot do so you have expectations about what the process is for and what the end result is going to be. An expungement cannot restore firearm rights, it cannot remove a person's requirement to register as a sex offender, and it does not restore a driver's license. There are alternative options if you are eligible for them to cover these top 3 bullet points, but an expungement in itself is not going to address those issues. An expungement also cannot purge or destroy the record of a case. It does not remove a strike if that underlying conviction was considered a strike, even after expungement. And then finally, it doesn't prevent a conviction from being considered as a prior in the event of future cases. With that being said, there are still amazing benefits to getting an expungement, and I think people come to us for a bunch of different reasons, but one of the primary motivations that we hear is around employment and housing. So effectively, what an expungement will do, it allows a court to set aside a conviction and dismiss that case. Once expunged, that conviction, that case should not be reported on a private background check. And in many employment and housing circumstances, that person can say they were no longer convicted of that expunged conviction and they do not need to disclose that expunged conviction. There are also other limitations about when an employer can ask about criminal history and when an employee or an applicant has to disclose it. And I'll talk about that throughout this presentation. So we talked about what the limitations and benefits of an expungement are, but I also think it's helpful in understanding what an expungement is seeing what an example of a person's rap sheet looks like after an expungement has been granted and noted on their rap sheet. Here is an example of purely made up information meant to look like a person's rap sheet, just to show you how this record is updated after an expungement is granted. So we can see here on this highlighted portion that the disposition was updated in 2018. As I mentioned, the court set aside the conviction and dismissed that case under an expungement law. As we can see, the information on this case is all still there on that rap sheet. This information doesn't go away on that document, and in some circumstances, this information is always going to be available for law enforcement, certain special employment, and licensing options. However, what this new disposition does, it will update this rap sheet, it will update the court record, and in those private background checks and those employment and housing contexts where it applies, you will not have to disclose it and it does not show up. Okay, so now that we have this foundational knowledge about what an expungement is, let's apply it to different concepts so that we can kind of understand the scope of an expungement and where it is beneficial and what things to look out for. Later on in this presentation, I do cover in our Know Your Rights session general employment and general housing, but I do want to cover two specific topics now. First, let's talk about occupational licensing. So in California, we have Assembly Bill 2138, which is a law that governs the process for many licensing boards when they are reviewing an application where the applicant has a criminal record. And I do say many licensing boards. AB 2138 does not apply to every licensing board in our state, so it's important just to make sure if that law does govern your board before applying, just so you know what to expect. Under AB 2138, an expunged conviction cannot be the basis for a denial of an application. An expungement can also help in providing support of a showing of rehabilitation. So you might be asked to produce evidence to show rehabilitation. An expungement can help support that, and also the documents you have prepared for your expungement can be used in this context as well. When applying for an occupational license, it's important to remember that you may have to disclose your criminal record even if your records have been sealed or expunged. It's important that if you're asked about it, you answer honestly. A non-disclosure can be the basis of a denial. It's really important to know what the requirements are in the process for the specific board you're applying to. So I always suggest that if you are looking to apply for a license, review the requirements, see if AB 2138 applies, see what information you can get on that board's website, and if you're able to, consult with a legal advocate, with an attorney regarding the process so you know what to expect. Another circumstance I want to talk about that we see often is how a criminal record may impact a person who is not a United States citizen. I do want to preface the slide by saying that I am not an immigration expert, and those of us on our Clean Slate Initiatives team, we are not immigration experts. There is a practice of law that does specialize in how immigration law interacts with criminal law, and that's sometimes called crimmigration. And we have a resource available on our website for referrals to different crimmigration experts, immigration experts available to you. But real briefly, I do want to cover this topic. If you're not a U.S. citizen, a criminal record can have serious implications on your immigration process. It can cause removal from the United States or prevent you from getting certain immigration benefits. An expungement is not going to completely erase your record, and this is especially true in the immigration process. And in fact, there are special forms of criminal record clearing that help non-citizens from being removed because of their criminal records. For folks who are non-US citizens, we always suggest to speak with an immigration attorney that has that specialized knowledge in how criminal records can impact the immigration process. We do have that referral on our website, so please check that out if the situation applies to you. And it's really important that you speak to someone who is knowledgeable in this field, just so you know exactly what your best option is. So now that we have this information about expungement, what are the eligibility requirements? When can a person apply, request, petition the court for an expungement? So in order to be eligible for an expungement, a person cannot be on probation, parole, or any form of supervision. They cannot be in custody or currently incarcerated. They cannot have any pending criminal charges, and they cannot have any active warrants out for their arrest. And so all 4 of these bullet points must apply in order for a person to be eligible for an expungement. There is one exception for this requirement. If you successfully completed fire camp for the case that you are currently on supervision for, and all other bullet points apply to you, then you may be eligible for expungement. So reach out to us and see whether or not we can assess your eligibility for an expungement. So we talked about what an expungement is, what the eligibility requirements are, and we've applied it to a couple circumstances. One of the first steps that we would go through when assessing a person's expungement eligibility in order to see whether or not they met all those bullet points that are needed, we would request certain records. So let's talk about getting your records that are needed for expungement. Seeing a person's criminal record is going to be necessary, essential when assessing a scope of their cases and whether or not they are eligible for expungement. We pull 2 different documents when we are looking at a person's eligibility. First is going to be their rap sheet. This is their record of arrests and prosecutions. In order for a person to get a copy of their rap sheet, they must complete a live scan, and I'll talk about that in just a moment. Another way that we look at records to get more specific information is to pull specific case dockets. So as I mentioned, one of the primary documents you'll want to request is your rap sheet, your record of arrests and prosecutions. In order to get your rap sheet, you'll need to complete a live scan. There are a bunch of different providers all over, but you can use this top tool here or scan this top QR code to go to a website, and it's very helpful. It'll find local providers and provide information on the cost of their services. And so just to let you know, there are 2 costs of getting a live scan done. One's going to be a $25 fee to get the live scan results, your rap sheet, and the other one's going to be for the live scan services themselves with that provider directly. There is a fee waiver available to waive the $25 cost, but you will still be expected to pay the provider directly for whatever they charge to get the live scan done. If you are interested in getting a fee waiver, you can go to this website here at the bottom or scan this QR code at the bottom. It'll ask you a couple questions and determine if you're eligible for that fee waiver and generate the fee waiver for you. So you got your rap sheet, and that's going to provide you with that bird's eye view of what your cases are that need to be addressed through expungement. But it's not going to give you every piece of information you'll need. You'll want to get more specific case information for each individual case that you have listed on your rap sheet or that you have on your record in general. Generally speaking, throughout the state, you can view case information in two different ways. You can go online to the court website in the county where your case is taking place. In LA County, that's lacourt.org, and viewing the criminal case summary. This is going to be a very limited view. It's going to provide you with a disposition, the status, and the different dates of the proceedings on the case. It's not going to provide you with all of the information you may need when completing an expungement or assessing that case's expungement eligibility. What you will need and what we pull in every single case that we work on is the case docket. This is going to contain all of the proceedings or events that occurred in the case, the minute order of every hearing that happened throughout the case's lifetime. You can request a court docket from a criminal clerk window at any courthouse. Now that we have this foundational knowledge about what an expungement is, and we talked about what kind of records that we would pull to assess our case and what the scope of that is, let's talk about what documents we might want to prepare for our expungement and what documents we often include with our clients when we're petitioning for expungement. So what do we include when we're filing for an expungement? Without getting too much into the weeds of expungement laws, there are two different types of an expungement. One could be mandatory, meaning the court must grant the expungement, and the other one is discretionary, meaning it can be up to the judge to decide. In most situations, an expungement is going to be discretionary. And so a discretionary expungement makes a judge consider if the expungement is, quote, in the interest of justice. That's the standard they will assess that expungement by. And that's a very vague concept, but really, if we apply the specific circumstances of the petitioner and what might prove as evidence of support or evidence of rehabilitation for that specific person, will include to show that it is in the interest of justice to grant this expungement. So one of the primary documents we'll include in our petition for expungement is a declaration. So we sit down with our clients and we ask them a series of questions to gather their life story, gather the information that would be important to painting the full picture of that person. We don't want a court to consider the expungement by just looking at the record of the case. We want to provide as much information as possible to really paint the full picture of who that person is. We want our declarations to be short, anywhere between 1 to 3 pages. If it's too long, a court may not read all of it. And some things to consider including is evidence of mitigation. So these are factors that could have been present at the time of your conviction or series of convictions. Evidence of rehabilitation to explain your journey since this time period. And finally, how an expungement would help you achieve your goals. So the tangible impact of getting this expungement granted. And this could be a bunch of different reasons, but namely we usually hear for employment purposes, housing purposes, or personal reasons. Along with our declaration, we like to include support documents, and I always encourage my clients to get as many as possible. This is going to be documents that help support the claims that you made in your declaration and help to support the showing of rehabilitation that the court will want to see when granting this expungement. Support documents could be anything that you might think is helpful, but here's a short list of what we often include. This is letters of recommendation, professional letters, or letters of support. These are letters from family members or loved ones. Certificates of completion, so this could be participation or completion in AA or NA, certificate of completing parenting classes, anger management classes, GED, any kind of certifications that you might have received. If you volunteer anywhere, you would get a copy of your volunteer hours or evidence of school or work history. So this could be a transcript, a diploma, or a letter from your supervisor or a colleague at work. So now that we've talked about what an expungement is, eligibility requirements, how to pull your records, and how to prepare documents, let's talk about different forms of supervision. And so some folks might be coming to this presentation and they might not be eligible for expungement yet because they are on some form of supervision. In this section, we do provide information on what different types of supervision there are and options that a person might have for early termination or early discharge from that supervision. Probation. If you're currently on probation, you can request an early termination of that probation by filing a motion with the court under Penal Code Section 1203.3 or Assembly Bill 1950. And because there's two different laws, the requirements are going to be different for each. So we always suggest to meet with a legal advocate and go over your eligibility for that motion and on how to prepare that motion. The rules aren't hard and fast about early termination of probation, and it's done in the judge's discretion, but generally speaking, a judge may not grant an early termination of probation unless all the terms of probation are completed, and these are the terms everything but the time. So if you were sentenced to fines and fees as terms of your probation, to complete a class, to Caltrans or community service, those would need to be completed. And then at least 50% of your probation term is completed. We do have a template for folks who are open to filing what's called a pro per motion. That is, you will file it representing yourself and you will represent yourself in court. We have a template for that for you to fill in the information that's necessary to make that motion. You can reach out to my colleague Eduardo Hernandez, that is his email here at the bottom, for that template and for the instructions. If you are interested in learning more about early termination of probation, you can scan this QR code to go to Root and Rebound's website to learn more. That will be a lot of educational material on requesting an early termination of probation. You can also contact the local public defender's office for the county that you're on probation in to request assistance in requesting an early termination. Let's talk about parole. If you're currently on parole, there's not that equivalent early termination of probation motion that you can make, but you may be able to request an early discharge from parole. There's a different process here, and it might vary depending on your situation, but here are two different resources. You can scan the QR codes or go to the websites provided to learn a little bit more information on what the requirements to requesting an early discharge from parole are. Mandatory supervision. This is in the context of a split sentence under Penal Code Section 1170H. So if you've received a split sentence, meaning that the court ordered you to serve both jail time and a period of mandatory supervision, you might be able to request an early termination of that mandatory supervision once you're released from your jail sentence. This request is made under a motion similar to an early termination of probation, Penal Code Section 1203.3. However, because of the nature of mandatory supervision, it is ordered by a court and the sentence is determined by a court. So granting an early termination of a mandatory supervision sentence is going to be a little more difficult, and courts are going to be a little less inclined to grant these requests. We recommend contacting the Public Defender's Office for assistance in requesting an early termination of mandatory supervision. Post-release community supervision, or PRCS. So if you were sentenced to a prison sentence and served prison time for certain crimes, you might have been released under post-release community supervision, PRCS. Sometimes this is referred to as AB 109 supervision. Once you're released from prison, then the county probation department oversees your supervision. PRCS must last for at least 6 months, but it cannot last longer than 3 years. And if you're currently on post-release community supervision, it's important to remember these two different goalposts in time to request an early termination. So if 6 months passes without a violation, you can request with your probation officer if you can terminate your PRCS. Probation department has the discretion to terminate at that point. We recommend that you submit supporting documents with your request, similar to the support documents we talked about in our expungement petitions. If 1 year passes without any violations on PRCS, then probation must terminate your supervision within 30 days. So if this applies to you, make sure that you are following along in this process, in this timeline, and making sure that probation does terminate your PRCS. Okay, so our final topic in forms of supervision will cover federal supervision and federal probation. Okay, so just to distinguish federal supervision and federal probation real quick, federal probation is going to be something granted in lieu of a prison sentence on a federal criminal case. Federal supervision is going to be tacked on in addition to your federal prison sentence. And so depending on which crime you were convicted of, you may be able to request an early termination in both circumstances if you were ordered to supervision or probation. After 1 year, you can make a petition directly with the court, and the court will review that petition. After half of the probation or supervision term that you were sentenced to, you can make the request directly with your U.S. probation officer. Okay, so now we're in our last portion of this presentation. Thank you so much for sticking with us. We're going to talk about some Know Your Rights information. So first, let's talk about fair chance employment in California. So in California, we have what's called the California Fair Chance Act, which went into effect in January 2018. Sometimes it's called Ban the Box. And under the Fair Chance Act, generally, an employer cannot ask an applicant about their criminal history before making a conditional job offer, and an employer cannot consider convictions that have been expunged, dismissed, sealed, etc. So there are exempt employers under the Fair Chance Act. Under Fair Chance, it's going to generally apply to most employers with 5 or more employees, but there are specific carve-outs in the law. And these exempt employers can ask about and consider an applicant's criminal history at any stage of the hiring process. These exempt employers are state or local agencies, criminal justice or law enforcement agencies, farm labor contractors, or employment for a position that requires an employer to conduct a background check by law. And that includes certain positions in healthcare field, supervising children, and positions of that nature. If you're unsure whether or not the employer you're applying to is governed by the Fair Chance Act, please reach out to us. If you are currently going through a process of a denial for employment based off of your criminal record, we do help with the situation, so please contact our office as soon as possible. All right, so here is an overview of the different steps of the Fair Chance process. And we're going to go into every individual step and provide a little bit more in-depth information here, but generally speaking, you should be monitoring your hiring process and making sure that the employer is meeting each of these qualifications under the Fair Chance Act. So first stage of the Fair Chance process, the job application and interview stage. So it's really important to remember that employers that are subject to the Fair Chance Act cannot ask or discuss an applicant's criminal history at any of these stages. So at the job posting stage, in the application for the position, or in the interview verbally. If you see or experience any of these questions or conversations about your criminal history at these stages, you can let the employer know that they are violating the Fair Chance Act, and you can also put in a complaint with the Civil Rights Department for this violation. And I'll include some information about that complaint process later. So by this time, after you've had the interview with the employer should not have inquired or asked or had a discussion with you about your criminal history at all. Once they've decided to extend a conditional job offer to you, then they are allowed to inquire or look into your background check. So once the employer has extended that conditional job offer to you and run your background check, then they will conduct an individualized assessment of the applicant and make their preliminary decision on whether or not to continue hiring that applicant. So after extending that conditional job offer and running the background check, the employer will then review the results and make a decision. They can either proceed with hiring the applicant or decide to take the job offer back. If the employer decides to hire the applicant after reviewing their background check results, then the fair chance process is completed. The employer followed every step up until this point and decided to continue with the hiring of that applicant. But the employer can also decide to make a preliminary decision to take this job offer back. So if the employer reviews the background check and wants to take back the job offer, they must conduct what's called an individualized assessment. And this is going to go over factors specific to that particular applicant and that particular job being sought. It's going to review different factors like the nature and gravity of the results of the background check, how much time has passed since the conduct on the background check, and what is the job that's being applied for. Ultimately, to justify a decision to take back a job offer, the employer must come to the conclusion that the applicant's background check has a direct and adverse impact on the applicant's duty on the job. Once they've conducted this individualized assessment and come to this conclusion that the applicant's background check has a direct and adverse impact on the duties of the job, they must send in a notice. This is often called the pre-adverse action notice. What's really important about this step is that if the employer ran your background check, conducted an individualized assessment, and decided they wanted to take back the job offer, they must provide this decision in writing to the applicant. They cannot just ghost you. They have to supply you with what's called a pre-adverse action notice. This notice should explain your rights under California fair chance laws, provide a copy of the background check results used to make the decision, and provide the applicant with an opportunity to respond. This timeline to respond can be whatever the employer provides, but it must be at least a minimum of 5 days. Okay, now we're on to step 4. So the interviews happened, the applicant got a conditional job offer, and a background check was run. The employer reviewed the background check and wanted to rescind the job offer. So they made a preliminary decision and notified the applicant of this decision in writing. Now the applicant has an opportunity to respond. An applicant can respond in a couple of different ways. Sometimes an applicant will get their background check results back and see that a conviction has been mistakenly reported on their background check. They might have gotten an expungement already and it shouldn't be appearing. The applicant may want to dispute the results, the accuracy of the background check. They would do that directly with the private background check company that compiled the report and also clarify any miscommunication that the background check made with the employer themselves. So if you have that order for expungement, provide it to the background check company and to the employer to let them know exactly what is within the scope of consideration. An applicant may also provide additional specific information about the cases that were addressed in the employer's preliminary decision, and they might also want to provide evidence of rehabilitation, evidence of mitigation as well, and this will include support documents similar to the documents that we talked about when preparing our expungement packets. Now that the applicant has responded, then the employer must review that response and all of the information that they've collected throughout this process to then make a final decision. So the employer may review all of this information and decide to hire the applicant, but they also can still choose not to hire the applicant after considering everything. The employer If they want to take back the job offer, they have to provide the applicant with a written notice of their final decision, the applicant's options for any challenges to the decision, any appeal options, and notify the applicant of their right to make a complaint with the Civil Rights Department. It's important to remember that an employer should not be ghosting an applicant. They cannot ghost you after finding out your background check results. And actually, in adhering to the fair chance process, you should know which step you're at every different step of the process. It's also important to note that this process is followed in every step. Ultimately, an employer may follow the Fair Chance Act and adhere to the rules within it, and still choose not to hire the applicant. But it's also really important to remember that even if they do follow every step of this process, they might have still violated the Fair Chance Act in some form or another. If this is your final outcome, please consider talking to a legal advocate about what your rights are to continue in this process, or consider filing a complaint with the California Civil Rights Department. And I'll include some information about that in just a moment. So as I mentioned in that fourth step of the fair chance process, an applicant has an opportunity to respond to an employer's preliminary decision. This might require the applicant to address a conviction or convictions, and how do we talk about that in that context? What's really important is that we're not relitigating the case. We're not trying to prove innocence or guilt again, but we should just focus on the facts around the situation, what led up to that circumstance, and what led up to that incident. You know, your mileage may vary on these different topics, but you might want to address responsibility or remorse for your actions, explain what you've done to complete the terms of your sentence on the case, provide any additional supportive documents, and emphasize that you are no longer the same person or what kind of growth you've gone through since the time of this conviction. So now that we've reviewed the Fair Chance Act, let's see if we can apply this information to this practice question. If you want to do the analysis on your own, feel free to pause this PowerPoint, this recording, and there are the answers in the next slide. So Cindy Client sought legal assistance and succeeded in getting her one misdemeanor theft conviction expunged. When Cindy applied to South Suites, the application asked if Cindy had any convictions in the state of California. Cindy was offered a job conditioned on a background check, and when the background check was run, her conviction was incorrectly listed. What can Cindy do in this situation? So let's go over this analysis. So I like to take this practice question sentence by sentence. So we know that Cindy Client got her one misdemeanor theft conviction expunged. So going into the fair chance process, we know that this conviction probably shouldn't be an issue for her. So Cindy goes ahead and applies to South Suites. There's nothing in this question that indicates that South Suites is exempt from the Fair Chance Act, so let's generally say that the fair chance is going to apply in this situation. In the application for South Suites, Cindy was asked if she had any convictions in the state of California. We can see that that's a clear violation of the Fair Chance Act. This is the first step of the Fair Chance Act in the job application and interview stage. This question cannot be asked at this stage. Cindy was then offered a job conditioned on a background check, and when the background check was run, her expunged conviction was incorrectly listed. So as we mentioned, an expunged conviction should not appear on a private background check. And here, South Suites ran that background check, and unfortunately, it came up on Cindy's results. So what can she do? So as I said, we can assume that South Suites is an employer under the Fair Chance Act. Cindy is entitled to a copy of her background check from South Suites. She can provide proof that her conviction is expunged through a court order or a minute order from the hearing on that expungement, and therefore it should not be considered as grounds for denying her application. Cindy can also report South Suites for asking the question on their application on whether or not she had any convictions in the state of California. That is a clear violation, and she can submit a complaint with the California Civil Rights Department and also inform South Suites that they have violated the Fair Chance Act in having that question on their application. Okay, and let's talk about our final topic in this presentation, housing. When we talk about California Fair Housing, we are applying the Fair Employment and Housing Act, otherwise known as FEHA. Under FEHA, housing providers can ask an applicant about their criminal history during the application process, so we can distinguish that from the Fair Chance Act. In the employment context, this question is strictly prohibited, but in the housing context, this question is allowed on the application. Similar to the Fair Chance Act, though, is that even though they can ask this question on the application, the housing provider must still conduct that individualized assessment to see how the person's criminal history, criminal record results do interact with the expectations of them as a tenant. What housing providers cannot do is deny applicants based off of having a criminal record in general. This would be what's called a blanket ban, and I'll explain that concept in just a moment. Housing providers can also not apply their criminal records policy differently based on the applicant's race, sex, national origin, or another protected characteristic. And finally, a housing provider cannot consider certain records, and we'll talk about that in a couple of slides. So as I mentioned, housing providers cannot issue a blanket ban against people with a criminal history. What is a blanket ban? So a blanket ban is a complete ban on something that doesn't consider individualized factors. So just saying no convictions, no criminal history, no felonies within the last 7 years. These are all examples of blanket bans. So instead of considering what the underlying criminal history result is, what the misdemeanor, what the felony convictions are, they're just going to completely ban you off of falling into that category and not consider you on an individualized basis or conduct an individualized assessment. And in this slide, we do include examples of blanket bans that we found on Craigslist. This is still happening and housing providers are still issuing these, and they're pretty shameless about it since they're posting it on the internet. As we can see, approval is based on criminal background, no felonies. And even on this example on the right-hand side, no felony convictions within the past 7 years. So that one sounds a little bit more specific and like it might not be a blanket ban because of that 7-year mark. But even though it has that look back period, it is still considered a blanket ban because they're not considering what type of felony conviction within the 7 years. They're just saying all felony convictions, no matter what it is. That's a blanket ban. As I mentioned, housing providers cannot consider certain types of records as well. So housing providers generally may not deny a person for arrests that did not result in a conviction, infraction level offenses, cases where the applicant participated and successfully completed in a diversion program or a deferred entry of judgment program, convictions that might have been sealed, dismissed, expunged, eradicated, etc., or juvenile records. And so those provisions are covered under the Fair Employment and Housing Act. I do want to distinguish that there are different housing providers, private versus public. Public housing authorities are federally subsidized public housing providers that are regulated differently than private landlords. By law, public housing authorities have to have a policy on what their application process is when accepting and denying applications when the applicant has a criminal history. This policy must be made available to applicants. It can be available on the website, or you can ask the leasing office with that specific housing provider. Okay, so let's see if we can apply what we learned about FEHA to this practice question. Again, if you want to do the analysis on your own, feel free to pause this recording as our answers are going to be on the next slide. Peter Peoples has a 2013 felony conviction for vandalism. Peoples was recently denied an apartment at Ocean View Apartments. The manager explained that Ocean View Apartments does not rent to any person who has been convicted of a felony. There are three parts to this question. Does Ocean View's policy violate fair housing laws? Would it matter if the policy was limited to felony convictions within the past 5 years? And what options does Peter have for dealing with this situation? Okay, so let's review the answers. So question 1, does Ocean View's policy violate fair housing laws? So as we remember, the Ocean View property manager let Peter Peoples know that they don't rent to anybody with a felony conviction. As we learned under this section, it's unlawful for Ocean View to advertise that they have a blanket ban or to issue a blanket ban on applicants with a criminal record under FEHA. By saying that they don't rent to anybody with a felony conviction, that would be a blanket ban. They're not even considering what type of conviction that the applicant received, and they're just issuing this prohibition on everybody that falls under this category. Would it matter if the policy was limited to felony convictions within the past 5 years? So as I mentioned in our example on the blanket ban slide, even though the look-back period is limited to a certain amount of years, it is still a blanket ban because they're still not conducting an individualized assessment or considering individualized factors on what the felony conviction actually is. And finally, what options does Peter have for dealing with the situation? So Peter can inform the landlord and Ocean View Apartments that it's unlawful to prohibit anyone with criminal records from applying. He can let them know this is a blanket ban and violates FEHA. And if this does not have any impact on Ocean View's decision, Peter can file a complaint with the California Civil Rights Department for a violation under his rights under FEHA. So as I mentioned, through the fair chance process and the fair employment and housing process, there is an opportunity for applicants to file a complaint with the California Civil Rights Department. So if you think you've been unlawfully disqualified from an opportunity for housing or employment and the Fair Chance Act or FEHA applies, you have a right to file a complaint with the California Civil Rights Department. We assist folks with making these complaints. So if you want our assistance, please reach out to us. Our contact information is in the next slide. But if you want to learn more about this process, you can go to this website here at the bottom or scan this QR code, and it'll give you a detailed overview of what the complaint process is like, what the timeline is like, and you can also make a complaint on the website directly. And that's it. That's the roadmap to expungement. Thank you so much for joining us. Here is some information on how to get connected with our organization. That number there is our hotline. You can call and speak to an intake screener and they can assess you for eligibility for our services. And there's our website for you to click around and learn more. We have a resource library on our website as well if you want to access those materials.